Hearsay evidence, exclusion rules, and the exceptions to the rule. I'm Ravi Chandrapala. As I introduced, this program is on exclusion rule and the exceptions to that. In this part of the program, I propose to consider the exclusionary rules and the exception to the rule. The understanding of these concepts. This part of the program is crucial to any submission that you are to make. We will also discuss the implications of inadvertently admitting hearsay evidence. Equally, understanding the safeguards that are available to the court to decide whether to admit the hearsay evidence or not. This is not to mention the circumstances in which an out-of-court statement can be used in court. What I have said here is my understanding of the legal concepts, and I would encourage you to read, research, and learn the subject. I hope you will find this part of the program helpful and enjoy it. Let's consider, in summary, what is the scope of the new rules of hearsay. The rules of hearsay now apply to the legal framework is to be found in Chapter 2 and Part 11 of the Criminal Justice Act 2003, unless there are specific provisions which allow hearsay evidence to be admitted. We considered in the introductory part that the proceedings must be criminal proceedings, which strict rules of law apply. And then the Criminal Justice Act 2003 has defined what hearsay evidence is. Not only that, it has also abolished the common law exceptions that used to apply, save and except for what is preserved in this act. Next point to remember is unless one of the exceptions apply, hearsay evidence is excluded. Once the hearsay statement is adduced in evidence, be it intentionally or erroneously, it cannot be undone. Once the hearsay goes in other words, it's in. There is no provision to reel back what is gone in. Next, let's look at how the law has been changed. There are several ways in which the new hearsay provision has changed the law. There's a definition of hearsay, which is narrow. Common law exceptions has been abolished, expressly what is preserved. One of the objects of the Criminal Justice Act 2003 was to overcome the problems of DPP and Kearley and Crown and Myers. We will look at those cases in a short while. What was the difficulty with these two cases, which we will consider, is that when Myers was decided, there was no equivalent or provision in law to that what exists now in Section 117 of this Act. In other words, this piece of legislation introduced what are called business documents. And also, the Court of Appeal took the opportunity to deal with the issue of implied assertions and highlight the problems of hearsay. Basically, the case of Hearsay, the facts are that the defendant was convicted of supplying drugs. The police had kept him under observation, and they noticed people were coming in to the place seeking for drugs. When the defendant's house was raided, whilst the police were there was no shortage of people turning up, asking for drugs. The prosecution claimed that the evidence of drug dealing from the premises, the Crown was allowed to adduce the evidence to this effect from the police. The defendant was convicted and he appealed. When to the Court of Appeal, the House of Lords upheld the appeal and quashed the conviction. The court said that it was an implied assertion and that it was, if a caller makes a call to buy the drugs, then saying to the police that they wish to report the defendant is dealing in drugs. So that was the situation. However, there was a dissenting judgment from Lord Griffiths. Now, in fact, that dissenting judgment is what is now regarded as the law. Lord Griffiths said, it is hardly surprising that the jury convicted the appellant. For, as a matter of common sense, it is difficult to think of much more convincing evidence of his activity as a drug dealer than customers constantly ringing his house to buy drugs and a stream of customers beating the path to his door for the same purpose. I believe that most laymen, if told that the criminal law of evidence forbade them even to consider such evidence as we are debating, this appeal would reply, then the law is an ass. That is how big the problem was when the case of Hearsay was dealt with. Then I mentioned the case of Myers. Here, a similar problem. This was a case concerning car rigging, basically selling stolen cars. And the police, needless to say, investigated the matter, went to the courts, and the prosecution wanted to establish the chassis numbers of the cars in order to establish these particular cars were stolen. So in order to do that, they wrote the cards, the workers of the assembly line had written the details, but not the factory workers. The defendant was convicted and he appealed. Again, the court held that the notes on the cards were hearsay. The court went on to say that they had no doubt as to the accuracy of the information, but there was no existing hearsay provision to adduce this evidence. Therefore, the appeal was allowed. It's beggars belief, isn't it? Absolutely. There's a document created in good faith, yet that cannot be adduced. So that is how now the rules have changed by bringing new provisions to deal with this issue. Now let's look at the admissibility of hearsay evidence. I have put various phrases in red brackets because they are the important words and phrases, I think, in this legislation, especially in section 114. It says section 114, subsection 1, in criminal proceedings. Remember, we looked at what criminal proceedings is, where the proceedings are conducted with strict rules of evidence apply. A statement. We'll have a look at what is the meaning of statement. Not made in oral evidence in the proceedings. That means the current proceedings. Again, we'll have a look at that. Is admissible as evidence of any matter stated if, but only if. It is only admissible, but only if. In other words, it is excluded unless it is. A, any provision of this chapter or any other statutory provision makes it admissible. In other words, either this particular act or there must be a specific piece of legislation which allows hearsay evidence to be admitted. B, any rule of law preserved by section 118 makes it admissible. Remember, I discussed earlier, common law exceptions are no longer operative unless they are preserved within section 118. C, all parties to the proceedings agree to it being admissible. Again, we looked at very briefly when we considered introductory part to this program. If all the parties agree, there is no problem. The question here, which we will look at in due course, when we look at the next section, admitting evidence, hearsay evidence by agreement. There are problems with that. D, the court is satisfied that it is in the interest of justice for it to be admissible. In other words, D gives a fantastic discretion to the court to admit where the court thinks it's in the interest of justice. The next part is the section or subsection 2. In deciding whether a statement not made in oral evidence should be admitted under subsection 1D, the court must have regard to the following factors. In other words, these are the safeguards provisions. And it goes on to say, A, how much probative value the statement has, assuming it to be true. In other words, is it probative value is better than the prejudicial value? If the prejudicial value exceeds the probative value, then there's a problem. And in relation to matters in issue, the proceedings, so how valuable it is for understanding of the evidence in the case. Now, certain pieces of evidence may very well have to be admitted in order for the case to be understood, albeit that it is technically hearsay. Otherwise, it doesn't make sense. Again, we'll look at that. For example, what comes to my mind right now is a threat to kill or threat in words and behavior, which is made outside of a court. But that part of the evidence is important to understand the case. Then B, what other evidence has been or can be given on the matter or evidence mentioned in paragraph A. In other words, in the absence of hearsay evidence, is there other evidence that could substitute and give the same effect without having to rely on hearsay evidence? C, how important the matter or evidence mentioned in paragraph A in the context of the case as a whole, which we looked at, in fact, earlier. The circumstances in which the statement was made, that could be pretty crucial, because hearsay evidence could have been made at a time when the person did not have any option but to make that statement. Therefore, concoction, it can be ruled out. The next thing is to look at how reliable the person is, how reliable the maker of the statement appears to be. If the maker of the statement is particularly got problems with his veracity, for example, that could be a factor to be taken into account. Then equally, the court will look at how reliable the evidence of the making of the statement appears to be. In other words, although that it is a hearsay evidence, can that be regarded as reliable? This we will look at in quite detail when we look at a case by the name of Clare that comes to my mind. G, whether overall evidence of the matter stated can be given, and if not, why not? In other words, although that it is hearsay, whether that evidence can be given in court. If not, why not? The amount of difficulty involved in challenging the statement. You got to look at the problem from the party who's at the receiving end. How difficult it is for that person to challenge. It may be that person or that party cannot challenge the evidence unless the person comes to court and gives this evidence. The final part is nothing in this chapter affects the exclusion of evidence of a statement on grounds other than the fact that it is not made in oral evidence in the proceedings. We have now looked at the safeguards provisions. The court would be keen to go through this particular part before a decision is made, whether to admit the hearsay evidence or not. Let's look at section 115. And I said earlier that the word statement is important, and we'll look at that. In this subsection 1, in this chapter, reference to a statement or to a matter stated are to be read as follows. 2, a statement is any representation of fact or opinion made by a person by whatever means, and it could include representations made in a sketch, photo fit, or other pictorial form. So, in other words, any representation is good enough. Even giving a thumbs up, that could be a representation. A mere nod could be a representation. And it could be fact or opinion. Now, people might raise their eyebrows when the word person is there. Believe you me, that is a very important concept. And it has to be made by a person. and it could be by whatever means, including representations, sketch, photo fit, or other pictorial forms. Then subsection 3, a matter stated is one to which this chapter applies if and only if the purpose or one of the purposes of the person making the statement appears to the court to have been A, to cause another person to believe, or B, cause another person to act or a machine to operate on the basis that the matter is as stated. In other words, you look what is the purpose, and the court will look at it and will decide. The maker of the statement, did he intended another person to believe the matter, what is being stated, or another person to act, or a machine to operate because of the information given. So the purpose is crucial here. And when we look at the concept, where do you find the hearsay evidence to be excluded unless admitted under a gateway? The key sections you would have noticed by now is section 114 and 115. What are the key verbs in section 114? There are two parts to it. First part is a statement not made in oral evidence in the proceedings. In other words, in the proceedings, you will soon realize the proceeding refers to the current proceedings. That is in question. 2, goes on to say the next part is, it is admissible as evidence of any matter stated in it, but only if. In other words, it will only be admitted in certain circumstances, otherwise it is excluded. So what is the effect of section 114, subsection 1? This section refers to admissible as evidence of any matter stated. The section only comes to life if the maker of the statement intends that statement to be relied or to establish a matter as to the truth of its contents. So, what is the effect of the meaning is admissible as evidence of any matter stated in it, but only if. The last few words of this sentence, if but only if, clearly established that section 114 is an exclusionary provision. That is why it can only be admitted, but only if. In other words, certain criteria apply.